case is 2024 CR 02904, simple assault. You are represented in both cases by Ms. Hahn, Chelsea Hahn, with the law firm of Lister Holton Dennis. Ms. Hahn, what is your client? You've indicated that your client is entering a plea of guilty on the case 2023 CR 10395 to theft by shoplifting, and that the case ending in 02904 is being amended to a county disorderly, and that also will be a guilty plea. Is that correct?
Yes, Your Honor.
All right. Ms. Kirkland, by entering these pleas of guilty, you give up. Did I swear her? No, I did not. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, thank you. By entering these pleas of guilty, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
Yes, Your Honor. For case 2023 CR 10395, the factual basis is that on October 18th, 2023, Officer Canoe responded to a potential disturbance at 6 Texaco here in Clayton County. Upon arrival, the officer made contact with the store clerk, who stated that earlier around 7:48 that morning, an individual who's identified as Cynthia Kirkland came into the store acting irate. And when they asked him to leave the store, they had stolen a box of incense that were valued at approximately $40 and cologne valued at $20. They did call the police, but the individual had left prior to the officer's arrival. However, the defendant did come back to the store acting irate again and refused to leave. This incident was caught on store video footage. And eventually, the officers did make contact with the defendant as they did come back to the store once again. And they were taken into custody. The recommendation in this case is 12 months, 2 days to serve, credit for time served, the balance probated for the defendant to complete an anti-theft course, pay a $300 fine, and complete 40 hours of community service and not return to the incident location. And in case 2024,
right, I got. Hold on, Ms. Williams, you're breaking up. So I got 12 months, 2 days, credit for time served, balance probated, anti-theft course, and then something else, and then 40 hours of community service.
$300 fine,
Okay.
Community service, and do not return.
Okay. All right. And then for the county disorderly?
The factual basis in that case was that on February 25th, 2024, Officer Newby responded to 3682 Fremont Drive in Clayton County in reference to a domestic disturbance. On arrival, the officer made contact with the victim in the case, who stated that she and Cynthia Kirkland were in a verbal altercation and that they lived together. At the incident location, she stated that the victim stated that while she and her girlfriend were in their room, the defendant knocked on the door. She knocked on the door and an argument started. And during the course of that argument, the defendant ran up towards Ms. Ward as if she was going to hit her. The victim then pulled out a can of pepper spray in order to defend herself and sprayed the defendant in the face. And the police were contacted after the incident. The state's recommendation is dismiss count 1, count 2 is 12 months to serve 29 days, time served.
County, it's only 6 months.
I'm sorry. Count one to be dismissed. Count two, 6 months, 29 days credit for time served, anger management course, an additional 40 hours of community service, and no contact with a HAYWARD.
All right. Ms. Hahn?
Thank you.
Your Honor, so regarding the, well, I guess this applies to both cases. Mr. Kirkland, he has let me know that he's struggling financially right now. So I told him that Your Honor is most concerned as far as probation goes with making sure that he's compliant with doing community service, that the money is not necessarily your number one priority, just making sure that he's checking in and communicating and also doing the community service. He understands that he's going to have to pay the fines, but I just wanted to let Your Honor know up front that that's going to be a bit of a struggle, but he does understand that he has this period of probation to pay, and that even incremental payments are going to be more beneficial, even in small amounts, than not paying anything. So we ask that you accept the recommendation on the theft by shoplifting case. And then regarding the county disorderly conduct, our office was contacted by a witness in the case, as well as the victim in the case, to inform us that this set of facts that the state has is not necessarily what happened that day. Just a small point of correction, that the alleged victim in the case is not the girlfriend of my client's ex-wife. They're just friends. Both of them let me know that Mr. Kirkland was just trying to get in the room, and they got upset, and she did pepper spray my client. Nevertheless, that's partially why. Correct, yes, Your Honor. So the alleged victim did threaten to kill my client initially. My client then lunged at her, and then she's pepper sprayed.
Not lunch, but like what? Like woke up.
Yeah.
To get clarification. What did you say?
Sorry, the word I used, I think, with the prosecutor was kind of like a bucking in response.
Okay.
But
Did she make some? After saying she was gonna kill.
correct. So that's why we negotiated the county disorderly conduct, Your Honor.
All right. Mr. Kirkland, do you have job prospects at any time?
Yes, ma'am.
Okay.
Vehicles so I can do my DoorDash.
Okay, DoorDash. All right. So this is like Ms. Hahn said, my priority is let's get those classes taken care of, and the anger management and the anti-theft class, and the community service. Let's prioritize those in the early days of your probation so that we can get the good that will come out of this case. Let's get that taken care of.
Yes, ma'am.
And then, once you have employment and the money is starting to come back in, then you start paying your fines and fees. We're clear?
Yes, ma'am.
All right. Now, the other thing. I don't need you in a jumpsuit. I don't need you in jail. I need you out living life. And so these are choices. My husband says all the time, we look exactly like the choices we make.
Okay.
And if you're making good choices, you look like those choices.
Absolutely.
If you're making bad choices, you look like those choices too. And so what I'm saying to you is, these are the kinds of things where the reason you're in here is entirely based on some choices you've made. Okay?
Yes,
And so I need you to think before you act so that you don't end up back here.
yes, ma'am.
All right? How old are you?
39.
You're just starting life. You got a whole, everybody say, oh, my 40s. But that's the part of life right there when you're living. By this time, by 40, you should have it figured out, in the sense that you should know, you're not trying to please anybody else. You're trying to please yourself. You're working for yourself. You're working to make sure you and your family are good. And so make those choices consistent with that.
Yes,
We
ma'am.
clear?
Yes, ma'am.
All right, Mr. Kirkland, thank you. You can go back with the sheriff's office and probation will see you.
Yes, ma'am. Thank you.
Thank
All
you,
right.
Your Honor.
All right, next is,
Your Honor, did we need a Spanish interpreter? Sorry for the interruption.
we needed a Spanish interpreter?
I don't know, Your Honor. I wasn't. She's here. If you didn't.
Oh, we're good. Thank you. We're waiting on a Vietnamese interpreter.
Thank you, Your Honor.
Okay, if you know a Vietnamese interpreter, tell them to call me.
Okay.
Layla Tanton,
I'm Your Honor.
can I have a file stamp for a motion to revoke, please? Thank you. Hi.
Hi. Can I ask a question about the story you were telling?
Which one?
About your work, when you were young and working. Did you have the confidence at the second job to say, no, I'm not doing this because of your Walmart experience?
Well, it's because, my mom empowers me, right?
Right,
And so she told me everything about unions and how you're supposed to have a break.
right,
But at that time, this is my very first job.
right. Yeah.
But then after that, I was just like, no, because I didn't want to disappoint my mom
Right.
by leaving that job.
Uh-huh.
And then when my mom gave me the okay to leave that,
Howard.
and then we had a conversation and my mom said, baby, don't let anybody ever mistreat you and you can always come home.
That's awesome.
So
That's cool.
after that, it's like, all right then.
Yeah.
But you know what I would do? I would pick up the phone and call mom and I say like, Mom, this is what's happening. I still do that.
I do too.
All right, we're gonna call 2023 CR 3464, State of Texas versus Layla Ray Ann Tanton. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Lauren Lupton, it's Tanton.
And are you Miss Tanton?
Yes, ma'am.
All right, and are we proceeding on the motion?
We
Yes, ma'am.
are, yes.
All right, Miss Tanton, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Layla Ray Ann Tanton who was placed on deferred adjudication for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams on October 2nd, 2023 and cause number 2023 CR 3464?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violating condition number 1, on or about the 11th day of March 2024 in Durham County, Texas. Defendant Layla Ray Ann Tanton committed the offensive assault in violation of condition number 1.
How do you plead to that, true or not true? True. All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and the state has taken into consideration cause number 729646, which is the assault that she pled true to.
I'm sorry, 729
I'm sorry,
6.
729646.
All right.
And we're taking that into consideration, but continue her on her defers to deny the motion and alter and amend for conditions of DDRF followed by mixed supervision and wait for placement in jail or amend for anger management. That's the recommendations by probation also, John.
All right. Is that the proposed
That
agreement?
is, I would like to make the court aware of kind of the timeline of events that we're for today. So Ms. Tanton was originally in custody since August of 23 until her plea in October of 23.
Mhm.
That was where the court ordered she be evaluated for felony drug court originally.
Mhm.
So she had the felony drug court evaluation, was not accepting to that because of the mental health issues that she had been diagnosed with prior to even being in this court. Then it was recommended or suggested that she do SATF, I think, or SAFP. And then because of the mental health issues was told, no, that's not the right choice. And then in January of this year, she was evaluated for DDRF. There, for some reason February of this year was evaluated for January. And then the results came in February of this year. But for some reason, the ball kind of got dropped where even though she got approved for DDRF in February, she never got on the wait list to go get a bed at DDRF. So this assault did happen while in custody at the Bear County Jail. She has not really been given an opportunity. So we are in agreement that she go to DDRF, but given the kind of delay, she's not in line technically right now for DDRF. We would ask that the court expedite her in getting a bed at DDRF. given how long she's been a guest at Kidder County.
All right. All right, this is what the court will do. Court will deny the motion, alternate amend conditions to include the MIC evaluation and DDRF while in custody, anger management, and you to remain in custody until transfer. And then what I will do is, Norma, we're off the record. Can you give us a phantom date? And I have to do what's called a phantom date. Otherwise, if it shows that you have a court date in the system, what will end up happening, if they were gonna take you, they won't because you have a court date. So we'll be back here in 60 days just to see where she is on the list.
Your Honor, right now, the current wait time is anywhere from 3 to 13 weeks for DDRF. I just want to make the court aware that although we'll bring her back for a status update, they don't necessarily give us where they are on the list any longer.
All right,
So
we'll-
we
we'll-
can still bring her back, but
We're gonna bring you back. We're gonna find out something.
Okay.
Or I may come up with something else if it appears that it's gonna be too long.
I appreciate it.
Okay. I'm thinking. All right, Ms. Ferguson, 60 days.
And then the only other request, I don't know if we want to go back on the record, is I think in the original terms, she was going to reside in Medina, Texas. However, her mother, and it would be a better environment if she could move to Harris County, Baytown, Texas, upon completion of the DDR.
Well, let's
If I'm getting
approach that.
ahead of
No,
myself.
yeah, let's approach that after we figure out this. What date, Ms. Ferguson?
June 17th.
All right, so we'll be back on June 17th. And if you check at the jail, it's not gonna show up in the system,
Yes.
but we know that's the date and you'll be brought back. And this attorney will be here to make sure everything goes smoothly, okay?
Yes, ma'am.
All right, do you have any questions about anything?
No, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Sharon Thorne, the defendant.
And are you Mr. Mascaro?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on count 1 alone. We're waiving count 2 and the habitual status.
Any objection?
No objection.
You understand you're charged with unlawfully carrying a weapon with a felony conviction? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered agreement will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Are you satisfied with the way you've been represented? Oh, you're not satisfied with the way you've been represented? I'm sorry, what?
No, I'm not satisfied.
Are you not satisfied because you don't like the offer and you would rather go to trial as a habitual offender? I'm trying to figure out what's your dissatisfaction. Where is that?
My bad. I heard you wrong. Yes, I'm satisfied.
All right, so let's start again. Are you satisfied with the way Ms. Thorne has represented
ma'am.
you? All right. Are you a U.S. citizen?
Yes, ma'am.
Ms. Thorne, are there any issues?
No, Your Honor.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. According to the plea, state is proceeding on count 1. Punishment is to be assessed at 7 years in the prison. There are no applications. The state is taking in consideration NIMAG number 7496671, 7496669, county court cause number 725-357, 731-856. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1, how do you plead?
No contest.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all its attachments.
Any
No
objection?
objection, Your Honor.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it?
Yes,
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I ask that you follow the plea bargain that we have come to with the state.
All right, anything you wish to say, Mr. Mascaro?
No, ma'am.
All right, the court will sentence you to 7 years in the prison, give you credit for any time served. Take in consideration NIMAC number 749671, 749669, County Court Cause number 725357, 731856, and there's to be no contact with Leticia Molina Dela Cruz. Is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Thank you, Your Honor.